So I have some
Please.
time. I mean, I'd like to give you at least 10 minutes to testify, Mr. Wright, today. So why don't we, Deputy Ames, please swear in Mr. Wright, and I'm going to allow Mr. Brooks to go into him, and we'll see how far we can get.
Mr. Wright, can you raise your right hand, please, sir, and let me know it's raised?
Yes, it's raised.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, Mr. Brooks.
Mr. Wright, I have read the rather lengthy email you sent some caseworker. Is that what we're going to discuss today, the things you said to her? Or is this...
No, what I would like to discuss is the fact of we're going off of all this, off of the evidence of abuse or neglect that was unsubstantiated. They're wanting me to take domestic violence classes for a domestic violence that was basically proven to be untrue and that I beat in a courtroom. So I don't understand really why.
Can we stop there a minute?
Yes, yep.
You were charged with domestic violence?
That's what started all of this. I got arrested. Yes.
All right. You were what court were you charged with domestic violence?
Lenawee County Court.
Mr. Brooks, I'm sorry to interrupt, but I do want to remind you that these parties are well past the adjudication standpoint. The child has been removed since June 21st, 2024. And the case services plan has been in place for several review periods. I think today is technically our, let's see, fourth or fifth review, perhaps. So fifth review. So if I could please make sure that you are staying within the confines of today's hearing, I would appreciate it, which is just the last report period.
Thank you, Your Honor. All right, moving on, sir. What have you got on your mind to the limited time we have today?
Those are things, and the reason why I'm bringing them up now and not before is because obviously it took this long to figure out the court processes and everything, and I am just now basically kind of getting up to speed on how this all works. So I apologize for bringing that up now and not before, but now I understand what is going on, and I understand the fact of we are going through all this off of something that wasn't even a thing. Like it didn't even happen. So I don't understand why Kenzie didn't even come to me when Christy went to jail. Why was I not given guardianship of my daughter? Because no one substantiated the evidence. All they did was talk to Christy's parents, her father, that was in on the false allegations.
Well, so you were never convicted of a thing?
No.
So you're asking the court now why you didn't get your child back at that point?
Yeah.
And you haven't gotten the child back since that point?
Nope. And the reason I don't...
In the last 3 months, you have not had the child with you. Is that right?
Well, other than when Christy brought her over to my house.
All right. My next question, following up on that observation from you, is this. The report that I'm reading says you have not participated in any of the case service plan that was designed for you. Are you aware of that?
Yes. And then there are reasons behind that.
What are the reasons?
One is, like I said, they want me to take a bunch of domestic violence stuff for a domestic violence that never happened. So that, I don't understand why that's even there. And honestly, the other stuff is I don't agree with it because this is all, I mean, none of this should even be in court right now because, there was no evidence of fucking any of
Okay, Mr. Wright, I'm not going to tolerate profanity this afternoon.
I'm sorry. Yes, I'm sorry. I'm a little worked up on this. But there's no proof of any violence or anything like that. The one allegation was proven to be false, and they're going off of a false statement, which originated all of this, Oh, for somebody
Okay,
that's already
I
biased towards
I
me.
just want to clarify something else for the record, for you, Mr. Brooks and Mr. Wright. So the adjudication order, reflects that back in July of 2024, that Mr. Wright entered a no contest plea to the allegations in the, petition, which would mean that the allegations in the petition, were taken and used to craft the case services plan. So I just wanted to make sure that the record was clear on that point, Mr. Brooks, as far as moving forward on relevant questioning.
As I
chime
recall, I was not present that day, but someone had to sit in for me, but I could be wrong. But in any event, to get back to you, sir,
Yes.
no, wait, I want to say something to you so you get it.
Yep.
I understand that you don't believe that there's been substantiated claims that justify your case service plan. Is that a fair statement?
Yes.
Now, once a court has made a ruling, there is no need for anybody to agree or disagree with what the court has ordered. It must be obeyed. Do you understand that?
Yes, but can I chime in on my part? When I made that basically no contest,
Yeah.
I hadn't gone to my court stuff for the domestic, so I couldn't say, "Hey, I didn't do this." But after that, I mean, so I basically, you guys kind of railroaded me into a corner where I had no choice but to stand no contest or say no contest.
Well, you had more than one option, sir. You could have pled responsible, not responsible, or no contest. Do you understand that?
I mean, yeah, I mean, that's what the no contest is, right? No, not guilty.
No, it's not at all. It's just the opposite. It means the court can treat the no contest plea as a guilty plea. Just the opposite of what you just said.
We go back to the beginning and restart this because obviously it needs to be changed because I didn't do anything.
We've gone way farther beyond what we needed to go for at this point. We're testifying to things that happened over a year ago. My notes indicate that Mr. Wright's rights were discussed and put on the record at that hearing, and he still chose to.
They were violated.
And so, again.
This is where the argument starts collapsing. Wright admits he rejected services because he disagreed with them, then reveals he misunderstood his plea entirely.
And I believe we are far beyond the scope of the last review.
Yes, Mr. Brooks, do you have any questions? Sorry, go ahead, Ms. Thomas.
Your Honor, I'm sorry. I just want to clarify for the record. This is really bothering me. Mr. Wright actually had a bench trial in which he testified on his own behalf. On July 26, 2024, Mom had taken a no contest plea and Dad had asserted his right to a bench trial. At that time, he didn't know Kenzie's birth date. He asserted that Mom was beat up by some other guy, and that's how CPS got involved. He admitted to using meth and would have used a couple of days prior from the trial. He was still living at a fifth wheel on a friend's property. He had a tree trimming service, but no license. There's just so much that we have in the record. And I just don't think it's appropriate for a review portion. And he's clearly not been paying attention and or intoxicated to the extent that he doesn't remember what's happening. And I think that we're wasting the court's resources at this point in time, unless he has something to say about what's happening in the last review period.
And for the record, I'm going to review that as well. This looks like this was a case that started with Judge Anzalone. And it may have actually been a bench trial in front of her. It doesn't look like I don't know. This is very strange. There's a lot of signatures from Judge Anzalone, but I'll review the record and make sure that the adjudication order is correct. But I do have, at least in the adjudication order as it relates to Mom, that father's bench trial was requested and was scheduled for July 26th. So that is pretty consistent with what you're laying on the record today.
And Your Honor, you did sign an adjudication order for Dad on July 26th. It looks like it was entered into the record or stamped on July 29th. And you did indicate that by preponderance of the evidence after a trial, the statutory grounds were met.
Okay. All right, anybody else have anything for the record as far as what got us here for Mr. Wright back in July of 2024?
Only thing I want to know is, are you going to schedule another hearing for him to continue talking about what's on his mind?
Mr. Brooks, if there's anything that he wants to testify to as far as the last court report, now would be the opportunity to do that. But I am not going to allow any further exploration into what happened in the summer of 2024. So if you'd like to lead him through any questions on that point, I'd like him to go through that, because I'm not going to reschedule this simply to allow him to talk about things that are inadmissible anyway for purposes of today's court review.
Did you understand what the court said, sir?
Yeah, basically don't bring up what has happened prior to the last review. So I do have something to bring up on that. Miss Moore is constantly making the allegation basically that I frighten her or whatever it is, where she won't meet with me or won't come to my residence and all this, and I'm out of control. But when she came and took my child, I mean, that would have been a prime moment to see exactly how I am at that point, to where I'm,
3 months
mad
ago,
or
sir.
upset. And I did nothing, just like I
Sir.
always do. I walked away because
Sir.
there's no point in making a big thing of it.
Sir, the judge wants to
Yes.
hear what you have to say about the last 3 months. And what you're mentioning.
Yeah, that happened in the last 3 months.
Oh, excuse me. I didn't know that. Do you recall when that happened?
It was, I don't remember the exact date, but it was about a month
Roughly.
ago.
All right. So it was in the last 30
Yeah,
days.
roughly.
All right.
Yeah.
And what did she say?
I'd say maybe a little bit over it, but yeah.
What did the caseworker say about you? That you what?
Just basically like how, well, obviously she, basically states like I am, and I don't know if she states it in her paperwork or whatever, but that's why she won't basically come to my residence and do whatever testing and the DNA and all that.
Well, what
need to
behavior
do,
did she describe?
And she won't do the home visit thing. She wouldn't come through the gate. Well, she's described it as she doesn't know what she's walking into, and basically that she feels unsafe.
I see. Do you have any opinion as to why she would think that?
Yeah, it would be the biased opinions of Christy's family, or her father mainly, and the allegations that started all of this, really.
Mm-hmm. Mm-hmm.
I've never given her a reason to feel like that towards me.
That was going to be my next question. Was there anything in your demeanor or your words that could have been interpreted as threatening?
Now probably other than nothing violent or anything like that, other than the fact of I want to see her in jail for basically taking my child from me or kidnapping her. But other than that, no, nothing out of means of the law.
Okay. So because the judge apparently is not going to give us that additional time in a week or so, is there any other point you want to bring up that has not been brought up by anyone else?
Just like the fact of basically with Kenzie being with Jason and Dawn, she's being alienated from basically my entire family, because they won't let my family have anything to do with them or her at all.
Remind me whose family they're with.
They're with Christina's family.
All right, moving on. Go ahead.
So basically, like my mother, her maternal grandmother, like she would love to see her granddaughter and be part of her life, but she cannot due to this. And it's because they are, they basically how they want it, and then how they want it since me and Christina got together, is to write me off as dead and just to push me under the rug.
So they're not
So
cooperating with your extended family to maintain that relationship. Is that right?
right, and like her mother, I'm supposed to be able to see my other two children that's with her mother uh once a week, and I can't even make a phone call to her because if I do, she'll just hang up the phone. So, and they're through Hillsdale County, so she's not even following the court order that's in place. So, I mean, what do I do here?
Have you tried going back to court and complaining about her behavior?
I have not yet.
Watch this contradiction closely. Wright denies threatening conduct while admitting he wants the caseworker jailed for kidnapping his child.
Yeah, but I mean, it's obviously she doesn't care what the law says because she's not following the judge's order now. So, what really good is that going to do?
They might yank the children away from her.
And but at that point, where do they go? Do they put them in even with somebody they don't know?
You're adding things
That
there
just
that
makes it
we're
worse
not
on them.
talking about. You ask what the potential remedies would be. I told you, and I told you the sort of threat hanging over her head.
Yes, and this whole thing is about the well-being of our children, correct? So
Sure,
in
I'm objecting to dialogue. This is really not an opportunity for dialogue. It's questions and answers.
Right.
This is the problem with court. You can't ever really get what you had to say out, and it's never really a thing to where anybody can understand exactly what's going on.
Mr. Wright, please stop. So the problem I think that we're having here at the moment is that these are questions that would have been appropriate for you to speak to your attorney about frankly, in an attorney-client privileged context so that you can get your questions answered before you come to court.
My attorney doesn't call me, doesn't get in touch.
Okay, Mr. Wright, no more interruptions, please. You've had your attorney's information for a significant period of time. I'm not going to entertain disparagement of Mr. Brooks on the record either. There's an order for supervised parenting time. So no, the relative would not be authorized to take any phone calls, any unauthorized phone calls. The only parenting time that your client's offered right now, Mr. Brooks, is a reintroduction parenting time program through Renee Moore because he's been absent. So I'm going to ask you to move on to something else if there's anything else, or to simply reschedule something so that you and your client can walk through where he's at in the case right now so you can take a better look at things on a different day for a review. And I'll offer an accelerated review to everybody. How about that?
Moving on, sir. What other issues do you want to address to the court?
Honestly, I guess none, because it's not going to make a difference. Obviously, I've seen that now. So
I don't recommend you take that tack, sir. What other issues do you want to bring up with the court?
Okay, so I'm in Lenawee County now. I have been for months now. I do not have transportation. I do not have a license. I don't really have any friends. I have barely any family here. So it's hard for me to get around. What can we do other than a gas card to help that become a thing to where I can go to these appointments?
My advice on that to you, sir, is contact your caseworker and work.
I have.
Oh.
That's all in the text center.
It's all in the what?
The messages I sent to Macy, caseworker. That's all in there.
All right.
I've mentioned it over and over again, multiple times throughout this whole thing. What can we do to help with transportation to get to these things?
Uh-huh. And what was the response?
A gas card, $25 gas card.
Without a car to put it in.
Yep.
Okay. So what you're saying, if I can summarize, is you have a real and present problem and which they have offered no viable alternatives. Is that a fair statement?
Yes, sir.
What is the next issue you want to bring up?
That's it.
Well, we might ask one more. When you were saying that your attorney never called you back, are you referring to me?
I have called the office a couple times, but I didn't receive a call back. Yes, but that was months and months and months ago. So that's irrelevant now.
I see. Do you have a case going in Hillsdale County as well?
There's a guardianship in place with Christina's mother. At the moment, yes.
It
Other than
has
that,
nothing to do with me, right?
no, it has nothing to do with you, and it has nothing to do with Lenawee Court.
All right. What would you like to see done that's not happening at this point in time?
I would like to revise what they want out of me, because it also states in their stuff that they want me to do in order for me to have visits with Kenzie is to obtain a car and a license, and I can't obtain a license for another year. And I mean, obtaining the car thing, I mean, I did that. That's how I got the driving unsuspended. That's what with me trying to do what I had to do for the court.
Mhm.
I mean, so now I got that over my head. Like, I
What
don't,
else?
as you guys, like, I'm in a spot to where I'm damned if I do and damned if I don't, because if I mean, to get to these places, I'm going to have to drive. That's the only other way other than, figuring something out. And in doing that, I'm breaking the law. So, I mean, I don't understand. Is the court telling me to go ahead and break the law to do what they want me to do? Or
No, they're not.
so then what option do I have?
Okay.
Again, this is a conversation you probably need to have with your client, not on YouTube, not in the middle of a court hearing, Mr. Brooks. So I would invite you to move on to something else or reschedule. I'm gonna offer everybody an accelerated review, if it works, on their calendars for December 1st at 1:30 p.m.
What else is on your mind, sir, that could improve the situation?
That's it. That's it.
Well, let me suggest what I think I hear that has, you haven't said it, but I can see it's where you kind of like to go. You'd like a review of the case service plan, which you don't
Yeah,
think fits your circumstances very well at all,
correct.
which might change a whole lot of things.
Yes, sir, it would.
That I heard. With that, I'm going to move on and say I have no further questions.
Hey, cross-examination, Ms. Thomas.
No, Your Honor.
Any questions, Mr. McFarland?
You have a bicycle, sir? Mr. Wright, do you have a bicycle? Did you lose him, Your Honor?
He's logged in. Mr. Wright, did you hear the question? Okay, maybe the signal maybe he's having issues with the signal at this point, but he hasn't had any so far. Mr. Wright, can you hear us?
Yes, I can.
Once parked, Lindley tries to repair the counselor's testimony by separating missed appointments, phone sessions, and positive screens. Instead, her explanations multiply.
Okay, Mr. McFarland has a question for you.
Do you have a bicycle?
Yes.
You're sitting in the driver's seat of a car right now, aren't you?
Yep. And I did state that I obtained the car. That's how I got the driving unsuspended.
Nothing further.
Any questions, Ms. Underwood?
Are you in a vehicle with Miss Lunley right now?
No.
Okay.
But hey, nobody in the vehicle.
So you say you don't have a vehicle, but you do. Is there nobody that can transport you
No.
with the gas cards that you're provided?
I did not state that I didn't own a vehicle. I own a vehicle, but I have no license to drive the vehicle. So the vehicle sits on my property now. That's what I stated.
And you're not willing to take any accountability for your lack of participation in this case service plan over the last 3 months or even a year?
Hello?
Your Honor, at this point, I just won't ask any more questions.
Okay.
Thank you.
All right. Did you have any other witnesses, Mr. Brooks?
No,
Okay. Mr. McFarland, let's go ahead with the recalling or rebuttal of your client if you'd like to for now.
Thank you.
I'd like to try to finish today.
Ms. Lemley, are you still there?
Yes, sir.
Okay, Ms. Lemley, you remain under oath. Go ahead, Mr. McFarland.
Can you turn your camera on and just pan around for us?
Yes, absolutely.
Thank you. Did you wish to respond to your former counselors? Take your sunglasses off first, because we're in court.
She's driving. Ms. Lemley, we're gonna need you to pull over. If
Okay.
you wanna continue participating, I am not gonna allow you to do that while you're actively driving the car.
Okay, I said I'm about to pull into my work parking lot right now.
Sorry, Your Honor, I did not notice that.
Oh, well, I don't even think we would have known unless you asked her to pan around.
I said I'm sitting at the red light that's on the corner at my work. So as soon as I can get through this red light, I can turn into work.
Okay, Mr. McFarland, are you gonna have any other witnesses?
No.
Ms. Underwood? No, Your Honor. Ms. Thomas?
No, Your Honor, thank you.
All right, so after Ms. Lemley is finished, assuming there's nothing else that's triggered by her testimony, we'll go ahead and conclude today's review. Is everyone available on that December 1st date at 1:30?
I'll be there.
Sorry.
That's okay. That's why I asked. While we're waiting for Ms. Lemley, let's look at calendaring.
I'm available on the 2nd for that month, but the 3rd to the 5th I'll be on as well if you're looking at any of those dates.
Tuesday, December 9th at 10 o'clock for 2 hours.
I'm available.
At what time, Your Honor?
10 o'clock from
Thank
10 to 12. I'd like to budget 2 hours to make sure that we get everybody's testimony.
What was that date and time?
12/9 at 10
For what?
for our next review.
Okay.
That'll be our 6th review in permanency planning. Ms. Lemley, we're waiting for you to let us know that you're in a spot where you can safely testify.
Yep, as soon as these cars right here pass, I'm turning in.
Your Honor, this is one of the reasons I don't like Zoom. It trivializes what we're doing here.
I mean,
And I apologize. I could not afford to miss another day of work.
Your Honor, I am taking a look at my calendar as I occasionally have cases with Judge Angelo. That was December, what date?
9th at 10 o'clock.
So 1st is not good.
Correct.
That's fine, Your Honor.
Good.
Okay, I am parked.
Thank you.
Okay.
Christina, it sounds as though you wish to respond to what your counselor said, correct?
Yes.
This is your opportunity. What's the first issue you disagreed with her testimony?
It actually was not my first biggest thing was not what she said. Miss Underwood had confused or misunderstood something I had said. I did not tell the court that the June or July dirty drug test that they are submitting. I did not tell the court that was from cleaning another resident's room. I was not even in housing at that point, so I would not have been in a resident's room. That situation in which I was referring to in my previous testimony happened back in December.
So are
I'm
you
not there
agreeing that,
following.
so are you agreeing that what the witness said is true, that you said that you did relapse and took meth, is that what you're saying?
The one. But
Okay,
Miss Underwood, her situation, she put two separate situations into the same situation.
So it's only one time that you actively took, and that was in July. Is that what I'm hearing?
Here comes the credibility collapse. Lindley denies using in July after apparently admitting a relapse, then suggests public spaces caused exposure, and says her counselor misunderstood.
Yes.
Thank you. Did you wish to clarify anything else your counselor testified about?
When she stated the fact that I personally missed all of the appointments, I did go back through my text messages. There were 3 separate appointments that she had contacted me to reschedule that never did or canceled last minute. And then she was the one that also said that I didn't have to come to the office. We could do our sessions over the phone. And so I assumed that when we were doing over the phone sessions, that those counted as sessions. She was also aware that the nights that groups were, I had to work. We discussed that right at the beginning of me being in outpatient. And then there were, when she said, you know, I wasn't real, that we had a little very brief conversation about me moving back to Jackson. She never mentioned anything about me not being ready. She was actually helping me look places up to move to in Jackson. And yes, that was a plan I was working on, being in contact with the Jackson store, transferring my job and everything. And so I guess there's a lot of things that she said here that, you know, she acted or said things totally differently face to face with me than the way that she just described and answered questions here.
Do you have any response to her saying you left the inpatient prematurely?
No, because her and I had quite a few conversations about the fact that, and even you and I had conversation about the fact that the distance between my daughter and me is a problem, clearly. You know, with the transportation with her, it is a problem. So everyone's recommendation and what CPS wanted is me to move back closer to her. I had multiple conversations with her about, you know, it makes me very nervous to move back to that hometown to be right back on my hamster wheel. You know, multiple times did we talk about these things. And so
Okay.
I told her, you know, I'm not really ready to just up and disappear out of all of this. And she said that, you know, everything would be okay, just reestablish myself with, you know, she encouraged me the best that, you know, I thought she could. Never one time did she tell me, I think you're making a big mistake.
Thank you. Okay. Would that be the totality of what you want the court to hear? Would you agree?
Yes, and then just to clarify that Miss Underwood was taking like 3 separate occasions and mixing them into one.
Thank you for that clarification. I have no further questions. We'll see if any other attorneys have questions for you.
Cross-examination, Ms. Thomas.
None, Your Honor.
Mr. Brooks.
No, Your Honor.
Ms. Underwood.
Okay, so let's get this straight then, Ms. Lumley. You indicated then that you tested positive in December 2024 for meth?
No, I did not say that. I did not say I tested positive for meth at all.
Okay, but you indicated that I was misstating what you said. So when we asked about 2 positive drug screens that were in May and July of 2025, you testified that you got those retested and that they were exposure levels, and that was likely due to you cleaning another person's room. Is that inaccurate?
Yes, that is inaccurate. What I said was that those 2 that came back of this year were sent back to the lab. They came back as an exposure level positive. It doesn't matter if it's an exposure level or a use level, it's still a positive drop. However, there's, in the recovery world, there is a difference between a use level positive and an exposure level positive.
Okay, so then did you use then, I'm asking you, did you use on May 5th, did you use in May of 2025 methamphetamine?
No, I did not use them then.
Okay, then how did you test positive?
That came back as an exposure level positive.
Okay, so how would you have been exposed to methamphetamine when you were in rehab?
Being anywhere, being on the bus systems, being at the shelters where I do community service. There's all kinds of places that you can be exposed to it.
Okay, and then the same would be on July 15th of 2025 when you tested positive. Was that also exposure level?
I'm
Your Honor,
sorry.
she already testified, she tested that there was a consumption. I asked.
I just want to look really quick in here.
Well, Mr.
Asked and answered.
They
if
have,
you might.
do I have a Halloween? Yes, we have two.
Okay, Ms. Bresnay, you accidentally, I'm sure accidentally came unmuted, and we've got enough to try to.
Wright's lawyer admits the service plan challenge came painfully late, while Lindley's lawyer calls the unauthorized visit a serious yet isolated judgment failure.
Get through here this afternoon, so please be careful of that.
Her objection is asked and answered, Your Honor. I asked her that very same question.
Well, I'd like to give her the opportunity to clarify with Ms. Underwood since she is,
I'll withdraw that.
Thank you.
Okay.
I'm gonna have to overrule it if you did. Go ahead.
So did you use in July of 2025 then?
No,
You just admitted to, when being questioned by Mr. McFarland, that you relapsed in July. So is that an inaccurate statement?
in the recovery world, any positive test is a relapse.
Okay, so then Ms. Reyes is lying when she indicated that you admitted to use for the July 15th of 2025 test?
I'm not saying that she's necessarily lying, maybe misinterpreting or misunderstanding something that I had said.
Okay, now you indicated in the last hearing that you did not have a vehicle to get to your colors screenings. However, you're driving now. So are you able to make it to your colors when you're called?
This I've borrowed. My vehicle is not legal yet.
But you can borrow cars to get to work, but you can't borrow cars to do your drug tests?
Very, very, very rarely can I borrow a car to get back and forth to work. And that's on a scheduling thing. That's not a call up randomly in the morning and say, oh, hey, I got to do this. This I had made arrangements for a special occasion because I was attempting to come down there to be there for court. But after talking to my boss, I could not miss any more work. So I had to come to work.
No further questions.
Okay. Let's head to comments and closing, beginning with Ms. Thomas.
Thank you, Your Honor. At this time, I believe that it's appropriate to ask for a goal change to adoption. I do not believe that guardianship is appropriate given the age of the child and given the lack of either engagement from the parents and or benefit from services from the parents. I think that this child deserves permanency and stability and finality. We do not have two parents who seem to be committed to addressing the issues that cause a child to come into care. It does not seem that there's even a baseline understanding of what's happening is really into their worlds. And I think that their credibility is very questionable at this point in time. Your Honor, Ms. Moore has definitely made reasonable efforts to assist this family in reunification. We've seen, based on their conduct and capacity, the lack of ability to work truthfully and or honestly or safely within this system. There's a lot of lack of accountability and deflecting and blaming others for the current situation in which these parents find themselves. However, that's not the child's fault. And I think that at this point in time, Your Honor, I know that we've already scheduled or have on penciled in an accelerated review. At which juncture I don't know that we would have time to, if the court does order us to file a petition at this point in time, don't know that that would be the date and time we could hear a termination hearing, or have a hearing on a termination petition. However, I think that's forthcoming. The current family placement is providing the child with everything that she needs, and that this child's also getting exposure to half siblings. And so I just think that what's happening apart from the parents is beneficial for the child at this time. And I look forward to any updates and hopefully maybe a turnaround for these parents. But I just, based on the report that we have from the Odyssey House, Ms. Reyes' testimony, Ms. Lemley today has impeached herself based on testimony from the last hearing, which is, easily on YouTube. And then she also impeached herself again in this hearing. I think Ms. Reyes really was correct when she said, maybe mom is still in the contemplative stage of recovery rather than an active recovery. So with that, Your Honor, I just ask for the continuation of placement, continue ordering the parents into the case service plan. I know that there's a lot of complaints from the parents about transportation. However, that is just one element of it. And there are several ways in which our parents who struggle with transportation do engage in services. I believe that we have a very competent team from the private agency that can assist with referrals. I think it's just a matter of communication. And while the department, the agencies have a duty to provide those reasonable efforts, the parents have an equal responsibility to comply with and engage in those services as well. And as I always say, our county and this court particularly demands active efforts from our caseworkers. And I believe that's what we always get. And this is more than just a monthly check-in and sending a name and number of a place where parents can call to engage in services, which is technically all that the law requires from us. So I think that at this point in time, we've done what we can from the agency's perspective. And there's just failure to benefit. And I think it's time to shift completely towards a goal of adoption. Thank you.
Comments, Mr. Brooks?
Well, based on what I'm hearing from my client, I wish he and I had communicated more closely quite some time ago, and I would have attacked this case service plan back when it was really and truly more appropriate. And I guess that's what I intend to do now, is file a motion to review that case service plan, which, based on what he's telling me, doesn't really fit his circumstances at all. I also would have corrected his misapprehension that the fact that he doesn't agree with some of this stuff is irrelevant once it's an order of the court. If he and I were talking, he would have known that. But I will be filing a motion to review the case service plan before the next hearing.
Mr. McFarland?
Well, Your Honor, I asked Ms. Moore, until the incident with the dog, if the agency was on track with my client's desire for guardianship. The answer was yes. It was the issue of my client being there, having her child introduced to the dog at the residence of Mr. Wright was the turning point. It wasn't the testimony, the discharge summary of the counselor. All this is obtainable. It was probably knowledgeable by the agency. It was past history. Despite that, my client was having unsupervised visits, Your Honor. I think her testimony is credible when she says that she's not at a point right now where it'd be fair to the child to have the child back, but she is on board with a guardianship. So why would she lie about that and then lie about what's happened with the dog? That doesn't make sense. Mr. Wright's in Adrian, in Lenawee County with the dog. She wanted to make sure the dog is going to be appropriate with the child. She made a serious lapse in judgment. We agree on that, Your Honor. She agrees on that, Your Honor, in retrospect. But it was not her intention to violate the court order. If it weren't for that, this hearing would not be a question. It doesn't sound of termination or not putting that on. We are asking that the goal remains guardianship. We're not asking for reunification because she's acknowledging that guardianship is in the best interest of the child, that goal continue as the agency had desired it to continue prior to that incident, that my client's unsupervised parenting time resume, but with her giving an exact itinerary. This is what she's going to be doing each and every hour of the day. So we know exactly where she is, what the expectations are. If there's a telephone call or they call her, she's going to pick up and pan around. I think there may have been perhaps some questions in everybody's mind. Is she with Mr. Wright right now? That's why I asked her to specifically pan around to prove that she is separate from him. She's not with him, that she's learned her lesson. I think her testimony is very credible that she would have exploded, that she didn't explode, because that was not appropriate for the child when this happened, but she was, and I think that's inappropriate. So we are asking that if the court does reject the guardianship, that it be a dual goal of termination and or guardianship if the court goes that route. But obviously our request today is for guardianship to remain on schedule, at least until we come to our next hearing. Thank you.
Ms. Underwood. Your Honor, it's unfortunate that we're in the circumstance that we are right now. However, it is my job to advocate for the best interest of this child and for permanency for her. She has been in care with relatives for over a year now, since she was a baby. And with respect to Mr. Wright, he's done absolutely nothing to provide for her or to work his key service plan, despite several attempts from the department and attempts to engage in the services. It's easy to play the blame game, but again.
But the child's attorney delivers the hardest reality check. 15 months have passed, Wright has made virtually no progress, and Lindley stopped supervised visits.
Whether he was convicted of issues or not, of crimes or not, the issues are still relevant to this case. As far as Ms. Lindley goes, I would say that we were all very hopeful that there was positive progress being made in her case. However, it is clear that there has been a backslide in the last review period. Unfortunately, Ms. Lindley got caught having the child around Mr. Wright. She purposely went there. She took the child there, didn't let Ms. Moore know, even though she's supposed to provide an itinerary of what she's doing for each parenting time. And again, we can call it a lapse in judgment, but again, there is no way a parent would believe that that's acceptable. And the excuse about a dog and making sure that they got along, why would that be a thought in anybody's mind? When
No more interruptions, Mr. Wright. You've had your opportunity to
Well,
participate.
everybody making.
I would recommend you reach out to your attorney before the next review. Go ahead.
when that was even a thought in her mind when a
No,
guardianship was.
hold on.
Mr. Wright, if you can't stop interrupting, I'm gonna have to excuse you from the meeting and you can just watch the remainder of it on YouTube. Please don't unmute again.
Your Honor, the fact that the dog was even a priority at that point just shows where Ms. Lumley's priorities lie. And again, I just think it's an excuse to get out of what happened. But again, Ms. Lumley was impeaching herself and being dishonest on the stand, talking about exposure levels. She's continued to miss drug screens since she's been put on colors. However, she's able to have a vehicle when she needs to get places that she wants to go. But her e-bike can't get her to do her drug screens. Since her unsupervised visits were taken, the department has offered her supervised visitations, which she has chosen to not participate in, as well as she's had the ability to FaceTime the child with placement and has not attempted to do so once since she was caught at Mr. Wright's home. Again, I think the priorities are misconstrued here, and I would encourage Ms. Lumley to take a good look in the mirror to determine, really what's going on here. And if she does need help, then she needs to admit that and get back into treatment so that maybe it's not too late for her to get her life together and get her kids back. Placement does allow this child to have regular visitation with her two full siblings who are in guardianship with another relative. I believe that permanency should be the goal here and that should be adoption at this point. There's just a lot that's been going on that is contrary to this child's best interest, especially with respect to dad. Again, we're no further than we were a year and a half ago, approximately. And again, Ms. Lumley's priorities seem to be in the wrong place right now. And again, it's in this child's best interest to pursue permanency, which I believe would be adoption in this case, Your Honor. She is currently in the least restrictive and best environment for her, and she is too young to express a preference as to where she would like to be at this time. Thank you.
Thank you. The court finds all interested parties are given notice for purposes of today's review and permanency planning hearing. The child in this case was born in January of 2024. She's very young. She was removed from the care of her parents June 21st, 2024. That means she's been in an out-of-home placement for over 15 months. And at this point, the court has to look at what it means for this child moving forward, and what's in her best interest, and whether or not it would appear that either parent would be able to continue successfully towards reunification in order to provide a safe and secure home for her, drug-free, criminality-free, and that would meet her needs. Mr. Wright has not been engaged in his case services plan for some time, including the last 3 months. I carefully reviewed the text messages that were provided today by Ms. Moore because of her concerns on how Mr. Wright was addressing her, and she felt threatened by those. His request to have the case services plan revisited, I think, will have to be handled very carefully by Catholic Charities, considering the content of these text messages, which, by the way, do not ask for assistance with transportation, but do certainly seem to contain several different ways of letting Ms. Moore know what he thinks of her, to be polite about it, as well as what he'd like to see happen to her, different ways she could meet her demise in different paragraphs. So if Mr. Wright reaches out to you to do that, Ms. Moore, I would ask you to actively engage Mr. Brooks in that process. And Mr. Brooks, I would ask you to be present during any family team meeting or team decision making, whatever you're calling it, sorry. So that you can try to help Mr. Wright navigate that space safely, both for himself and for Ms. Moore, if he does want to revisit that case services plan. But I would note that at this point, we're 15 months in. There was an adjudication held. He did admit to substance use at that point and to criminality. He was incarcerated at the time the petition was filed. There's an active warrant out for his arrest at this point. There's no information on housing, employment, or progress in any other areas of his case services plan. And there does not appear to be any effort to reconnect with his daughter through the reunification opportunity given to him that's been outstanding for, I think, at least 2 review periods. So there's certainly a significant risk of harm associated with returning his child to his care right now. There has been, and there does not appear to be any movement whatsoever on those case services plans that would allow us to return the child to his care. As it relates to Ms. Lemley, there was a lot of very concerning testimony across the 2 days of this review and permanency planning hearing that was inconsistent. I sincerely hope that she is still in her recovery and that she can show that through some drug screening. The testimony by Ms. Reyes today was very concerning also, that she had abandoned her rehabilitation efforts early, both through inpatient as well as outpatient. That was actually new information that came to the court's attention today. The excuses about testing positive for exposure levels that could be contaminated from anywhere is simply incredible. And I do agree with Ms. Underwood that there are significant concerns at this point about what's actually happening with Ms. Lemley in her recovery. But nevertheless, at this point, she has appeared to make some progress in some areas, but again, we don't have anything from a current counselor. We heard that she didn't complete counseling services with Ms. Reyes. So there's a lot of outstanding areas of concern still with Ms. Lemley. She herself today has shared with us that she supports a goal of guardianship. The child is very young. She's very comfortable where she is. She's doing well there. And the fact that Ms. Lemley cannot provide for Ms. Wright, admittedly at this point, simply leaves it to the court and the professionals to determine what is the best course of action for her daughter moving forward. And that is adoption. She's very close with her relative caregivers. Neither parent is proving to be a resource to this child at this point. If I were to consider guardianship, I would look at whether or not these parents have an investment or a bond with their child in a positive way that would help her to grow. At the last visit Ms. Lemley's decision to take the child to Mr. Wright ended up with, and to lie about it directly before she went there to Ms. Moore, and then to try to blame it on the dog is remarkable. The child came back very unclean, and we have evidence of that as well. We know Mr. Wright is not in active recovery. We know Ms. Lemley's at significant risk of relapse. There's just so many concerns here in allowing these parents to even continue to have contact with this child because of the liberties that they're taking with her. She needs to be in a safe, stable home, free of domestic violence, free of substance use, and free of things that will compromise her ability to grow into a responsible adult, as Ms. Underwood put it. So there's a lot of reasons, but those are the main ones that the court is considering in changing the goal to adoption moving forward. I am going to leave the December 9th date on the books. If the termination petition is timely filed and served by the department, we'll conduct the trial as part of that next review and permanency planning hearing. In the meantime, the child will remain in her relative placement. That is certainly the safest and least restrictive under the circumstances. We'll have plenty of time for the review, even if it doesn't also encompass a hearing on a petition for termination of parental rights, but the order will reflect that that has been directed by the court today. I am certainly fine Ms. Moore in satisfaction for applications, Ms. Underwood and our advocates. Thank you everyone for your time, efforts, and testimony today. Good luck to everyone between now and when we come back in December. And unless there's any questions, that's all for today.
One question. For termination, the petition had to be filed in the statutory time frame, correct, right?
Timely filed and served is how I like to phrase it.
Thank you. Thank you.
Any other questions?
Finally, the judge lowers the hammer. Threatening messages, an active warrant, abandoned services, inconsistent recovery claims, and unsafe parental choices outweigh every excuse. The goal changes to adoption, the child stays with relatives, and termination proceedings move toward December.